For years, suppressor owners have lived in legal limbo, treated like criminals for owning what's basically a hearing protection device. But now, with the Fifth Circuit yanking its own ruling in U.S. v. Peterson, we're looking at the most serious shot yet at bringing suppressors under full Second Amendment protection. What's up, everyone? This is Ted from Line 45, and today, we're digging into how this one federal case could blow a hole straight through the NFA's suppressor restrictions and what it means for every gun owner who's tired of treating safety gear like contraband. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable car-related content on your screen. Now, buckle up, and let's get back to the video. Suppressors aren't just range toys for me. They've made real-world shooting safer for my ears, my neighbors, and anyone else nearby. But the legal system hasn't seen it that way. In February 2025, the Fifth Circuit Court of Appeals ruled in U.S. v. Peterson that suppressors aren't arms protected under the Second Amendment. That meant, in their view, they were just accessories, subject to whatever laws Congress wants to slap on them. For anyone familiar with the National Firearms Act, NFA, this decision solidified the idea that the ATF's $200 tax stamp and slow walk registration process were legally bulletproof. But then, something rare happened. On the 17th of June, 2025, the same court issued a one-liner. They were withdrawing their opinion. No reasoning, no replacement ruling. Just gone. What that means is simple. Peterson is no longer a legal precedent, and the court likely has plans for a rehearing, possibly by the full en banc panel. It's a big moment because courts don't walk back decisions like this unless internal pressure or legal errors force their hand. And with the federal government now admitting that suppressors are arms, but defending NFA rules anyway, the Fifth Circuit is stepping back into deep water. And this time, they'll have to answer to Bruin. Next, let's rewind and lay out exactly what the original ruling said and why it raised red flags for shooters across the country. Back in February 2025, when the Fifth Circuit panel released its ruling in United States v. Peterson, it made waves in the 2A community, mostly for all the wrong reasons. The court stated that suppressors aren't arms protected by the Second Amendment, brushing them off as non-essential accessories. According to the panel, because a firearm can still function without a suppressor, it's not constitutionally protected. That reasoning set off alarms for a lot of us, because it completely ignored how District of Columbia v. Heller and New York State Rifle and Pistol Association v. Hell, Bruin define arms, tools in common use for lawful purposes. Let's pour all the facts here. Suppressors are legal in 42 states, used by law enforcement, hunters, and everyday shooters. They're not just about comfort or aesthetics. They reduce hearing damage, cut back on noise pollution, and make shooting safer, especially on private property or in rural settings. The court's logic ignored that practical reality, and instead treated suppressors like they were optional bling. It also stepped around Bruin entirely. Bruin says courts must look at text, history, and tradition when evaluating gun laws. There was zero historical analysis in this opinion. That's what made the decision so weak on legal grounds, and why groups like the Firearms Policy Coalition immediately filed for rehearing. This wasn't just about suppressors. If a court could label anything detachable or add-on as outside the Second Amendment, scopes, braces, even mags could be next. That's what made this ruling more dangerous than people realized, and it leads right into why Petersons Case is so important. This case didn't come from some high-powered gun lobby or a national organization flexing in court. It started with a regular guy in Texas, Matthew Peterson, who was prosecuted under the National Firearms Act for possessing an unregistered suppressor. No violent crime, no illegal sale, no trafficking, just a suppressor that hadn't been run through the NFA's clunky process. And under federal law, that was enough to charge him with a felony. What made Peterson's case different is that it wasn't just about challenging the penalty. His legal team, backed by the Firearms Policy Coalition, went straight for the jugular. They argued that suppressors are protected arms under the Second Amendment, and that the NFA's tax, registration, and waiting period scheme, specifically as applied to suppressors, is unconstitutional under the Supreme Court's Bruin standard. That's a bold challenge, but it's grounded in solid precedent. Bruin made it clear that if a firearm or accessory is in common lawful use, the government must show that any regulation aligns with this nation's historical tradition of firearm regulation. Suppressors are owned by over 2 million people nationwide. They're not exotic, they're not uncommon, and they're not used in crimes at any meaningful rate. So Peterson's case isn't some fringe attack on gun laws. It's a focused, principle-driven attempt to test the constitutionality of the NFA, specifically where it veers into regulating common, non-lethal accessories used for safety. The implications go way beyond this one guy's suppressor, and as I'll discuss next, the court's withdrawal of the original ruling shows just how seriously they're taking that. When a federal appellate court reverses course and pulls its own published opinion, it's not a routine correction. It signals something deeper is in play. On the 17th of June, 2025, the Fifth Circuit Court of Appeals issued a one-line order. The panel opinion in U.S. v. Peterson was withdrawn. No elaboration, no substitution. Just gone. For those of us watching this case closely, it felt like the court hit the brakes hard, possibly in response to legal pressure from within or a fundamental flaw in their earlier reasoning. Here's what we do know. Peterson's legal team, backed by FPC, filed a petition for rehearing en banc, calling out the February opinion for ignoring Bruin and dismissing suppressors without any historical analysis. But the real twist came when the Biden administration, through the DOJ, changed its position. Instead of doubling down on the not an arm argument, the government conceded that suppressors are arms protected under the Second Amendment. They still claimed the NFA was constitutional, but their pivot pulled the rug out from under the original ruling. That shift mattered. It meant the Fifth Circuit was now standing behind an opinion even the feds weren't defending anymore. Combine that with criticism from gun rights attorneys, legal scholars, and even within the court itself, and the panel's opinion became untenable. So now the case resets. Likely path? A full en banc rehearing with all 17 active judges on the Fifth Circuit weighing in. And that's not just a redo. It's a chance to redefine the NFA's relationship to the Constitution. With the Fifth Circuit's withdrawal of the panel opinion, all eyes are now on what comes next, and that likely means a full en banc rehearing. If granted, that puts the Peterson case in front of all active judges on the Fifth Circuit, not just the 3 who issued the now withdrawn decision. And for folks who follow 2A litigation closely, this is big. The Fifth Circuit is one of the most Second Amendment-friendly courts in the country. It's the same circuit that ruled in favor of striking down federal restrictions on gun possession for people under domestic restraining orders in U.S. v. Rahimi, before SCOTUS reversed it. So this court has a track record of pushing constitutional limits. Now, with Peterson, the issue is more targeted. Can the government force registration, taxation, and prolonged approval processes for an arm that's in common lawful use? That's the heart of it. If the court accepts that suppressors are indeed arms and applies Bruin faithfully, then the NFA's suppressor provisions are going to have a hard time holding up. If the Fifth Circuit rules in Peterson's favor, expect the government to petition the Supreme Court immediately. And that's where it gets national. A strong 2A ruling on suppressors would create a circuit split if other courts rule differently. That would practically force SCOTUS to weigh in. This isn't just a Texas case anymore. What happens next could reshape how accessories are regulated across the country. And if suppressors fall under 2A protection, the next dominoes are already lined up: short-barreled rifles, braces, and beyond. And at this point, I think I can project what that future might actually look like. The moment suppressors are officially recognized as Second Amendment-protected arms, the foundation holding up their regulation under the National Firearms Act starts to crumble. Right now, buying a suppressor means submitting fingerprints, photos, a $200 tax, a long wait, sometimes 9 to 12 months, and then being permanently tied to that serialized can, unless you file another round of paperwork to move or modify it. For many shooters, especially hunters or folks running suppressed rimfire for plinking or pest control, that red tape is the only thing keeping a suppressor out of their hands. But that entire structure depends on the idea that suppressors are just regulated devices, not constitutionally protected tools. If the Fifth Circuit affirms that they are arms, and that current laws fail the historical scrutiny required by Bruin, then the feds will have to justify, with real 1791-era analogs, why taxing and registering a non-lethal, widely used safety device is consistent with the Constitution. and they're going to struggle to do that. Look across the Atlantic and you'll see the irony. In countries like Norway, Finland, and New Zealand, suppressors are unregulated or encouraged as a matter of public health. Yet in the U.S., the birthplace of the Second Amendment, we treat them like contraband. If Peterson leads to suppressors being deregulated, the impact would be massive. Dealers wouldn't need SOT licensing, buyers wouldn't wait months, and regular folks could finally use basic noise protection without federal surveillance. That opens the door to re-examining everything under the NFA, and it's why gun owners across the country should be paying attention. So with all these things going on right now, I want to talk about what smart shooters should be doing right now. If you're a shooter who owns a suppressor, has one in ATF limbo, or has been holding off because of the red tape, this case could be a game changer, but it's not time to jump the gun just yet. The Peterson decision is in a holding pattern right now. The original panel opinion is gone, yes, but a new ruling hasn't replaced it. We're likely looking at a rehearing, potentially en banc, and that means things are going to take time. So while the direction looks good, this isn't a green light to start ignoring NFA rules. In the meantime, pay attention to the Firearms Policy Coalition. They're at the center of this legal fight and post real-time updates straight from the court filings. Watch for an order from the Fifth Circuit either granting or denying a full rehearing. That'll tell us how serious the court is about taking another look under Bruin. If it goes forward, that means the judges are preparing to dig deep into whether the NFA's suppressor rules can actually survive the historical test. Also, keep an eye on SCOTUS cert petitions. If this case makes it that far, it'll be the first time the Supreme Court has had a clean opportunity to rule on suppressors and the Second Amendment. Bottom line, don't break the law, but don't tune out either. This case could reshape federal gun laws more than Bruin did. And if you care about getting rid of pointless restrictions that punish responsible gun owners, now's the time to stay informed, organized, and vocal. What happens in Texas won't stay in Texas. Not this time.